कोड नंबर कब लॉग किया आपने?
Sir, I finished my in 2019. I did BA honors from Dr. Ramanu Lena and
Dr. Ramanu Lena, no.
Yes.
क्यों लॉग किया?
Sir, my passion for law had been my driving force towards this particular thing because I used to see that if there is somebody or something that we all as citizens look upon to is justice and law and order to be maintained, there needs to be a third wheel, and that is judiciary. So, sir, why not?
Do you think law and order is maintained by judiciary?
No, sir. Law and order is maintained by executive, but then to proceed that whether it has been properly implemented, whether the people are not grievanced by the particular maintenance of the law and order, there is this third organ, and so there needs to be a balance about the same.
So you did law to maintain law and order.
No, sir. I did law because I believed I would. It was my sincere desire to be part of a system that upholds justice or protects the rights of individuals and contributes to the progress of the nation.
If you become judge,
Yes, sir.
how you can protect individual justice, rights and justice?
So I would just be trying to learn things from my seniors, from the seniors, and
You
therefore
just said you
Yes.
just become a part of the judiciary justice system to protect the rights and to deliver justice. How you can protect?
So I would try to be efficiently doing my job as a judicial officer, learning myself through it, and then just going through the way of providing justice to the people.
आज आप क्या पढ़ के आए हो सबसे अच्छा?
So I believe, so CPC.
CPC. This is your favorite subject.
So I do not have an inclination towards a subject. I believe I've equally tried to inculcate
Equally
things.
you
But
have read all the.
sir, today, sir, as per your
Equally you
question,
have read all the subjects.
so equally I've tried to make efforts towards all the subjects. But so today, at the top of my mind, I just answered it as CPC.
At the top of your mind.
Yes.
ज्ञानवापी के बारे में कुछ जानते हैं?
Yes, sir.
क्या? ज्ञानवापी का जो प्रकरण चल रहा है
जी,
देश
सर।
में हमारे,
जी सर.
पेपर पढ़ा है आज?
So,
2-3 दिन पहले से पेपर पढ़ रहे हैं?
yes, sir.
तो ज्ञानवापी का पता ही होगा ज्ञानवापी क्या है?
Yes, sir. So,
क्या चल रहा है?
So, it's actually about a fact that it's two parties telling that there's this one party which is saying that there was this very oldest and prestigious temple, Kashi Vishwanath temple, and besides that temple there is this Gyanvapi masjid. And what the claim is being made because of the fact that there were many evidences found from that particular Gyanvapi masjid by the Archaeological Survey of India very recently after the court orders, and so the evidences are compelling.
सर्वे.
Yes, sir.
सर्वे आप जज हैं, आप सर्वे का ऑर्डर कैसे देंगे? किस सेक्शन में देंगे? सीपीसी में देंगे, सीआरपीसी में देंगे, एविडेंस में देंगे, कहाँ में देंगे?
So, for the purpose of, sir, I'm not very sure. Can I make a guess?
Do you think there is any scope in law of guess? Do you think
No, sir.
there should be any scope
No,
of
sir.
guess?
No, sir.
नहीं ना?
Sorry, sir.
Law is science or law is an art?
So, law is an art subject.
Jurisprudence पढ़ा है? Is it art or is it science?
So, it is a field of formal science as per Holland.
It is a formal science.
Yes.
क्यों?
So, because what the law is made, it is standing there. It cannot change by subjects.
No. Science is, in a given set of circumstances, the result will always be the same as science. When the circumstances are the same, result will be the same. This is science. But art, it is not like that. In a given set of circumstances, art may or may not. What is given? It is given in jurisprudence.
Yes.
Right? May or may not.
Yes.
This is an art. Now what do you think? Law is art or law is science?
So now I think law is science.
Law is science.
Because in the giving, as per sir you said, in the giving set
In a
of
given set of
circumstances.
circumstances, the result will always be the same.
Yes.
ये साइंस है,
Yes sir.
राइट? 302 में एक स्टेप किया किसी ने, चाकू मार दिया, ठीक? एक पर गोली मार दी,
जी सर.
तो सर्कमस्टांसेस क्या बताते हैं?
When a person with the intention of causing death does an act, then he will be punished for murder or culpable homicide not amounting to murder.
Correct. बहुत बढ़िया. Very good. Now I just want to, what is the, मैं एक कार लेके चला, मैं आ रहा था अभी इंटरव्यू लेने, एक कार लेके, और एक एक्सीडेंट हो गया, एक इंजरी हो गई उसको बहुत तेज, यहाँ आने में मुझे 1 घंटा लेट हो गया, मैं उसको ले गया पहले हॉस्पिटल, मैंने एडमिट कराया, एडमिट कराने के ड्यूरेशन में वो मर गया, क्या है?
Sir, you did not have the intention to commit the death of that particular person. It was an accident. So, sir, it would fall within death by negligence.
It will fall in
Death by negligence, section 304A.
304A.
Yes.
मेरे पास लाइसेंस तो है, मुझे नॉलेज तो है
Yes.
कि मुझे काम ठीक से करना चाहिए, लेकिन मैंने ठीक से नहीं किया, मैंने मार दिया उसको, मेरे पास लाइसेंस तो है भाई,
Yes, sir.
तो फिर मुझे नॉलेज है,
Yes, sir.
लाइसेंस जैसे ही मुझे मिला मुझे नॉलेज है,
Yes, sir.
मुझे ये नॉलेज थी कि मैं अगर गाड़ी को रैश ड्राइव करूंगा तो ये मर जाएगा,
Yes, sir.
तो मुझे नॉलेज है,
Yes, sir.
तो फिर 304 क्यों होगा ये?
So, because of the negligent act at your part, sir.
मुझे नॉलेज थी ना,
Yes, sir. So you had
चलिए,
the knowledge
मैं
that.
कोई बात नहीं, कोई बात नहीं, मैं रोड पे जा रहा था और मैंने अभी कल का केस है, कहाँ पर है, समवेयर इन मुंबई, 4 लोगों को हिट करा और ट्रक ने चढ़ा दिया, कल रात का केस है। ऐसी सिचुएशन में क्या होगा? ये भी रैश एंड नेग्लिजेंट एक्ट है मेरा?
No, sir. Sir, because the brutality of the case is more, and a person who is driving at night and that too a truck, which is a huge vehicle, he should take care of the fact, and the act was so eminently dangerous that it must in all probability cause death.
What is this?
So this is murder.
302.
Explanation 4, sir.
302.
So 300 explanation 4, yes, sir. Punishment in 302.
302.
Yes, sir.
Confirm.
So if the, yes, I believe if the brutality is so that it was so eminently dangerous, it can fall within culpable homicide not amounting to murder also, sir.
मैं इससे दूसरा क्वेश्चन करेक्ट करता हूँ. What is the difference between 302 and 304? Meaning murder and culpable homicide.
Sir, culpable homicide is the genus and.
What is the basic difference? Thin line.
Sir,
Tell me that line only.
Sir, murder is a type of culpable homicide, and culpable homicide becomes murder when it falls within the very explanations of
What
300,
is
section
that?
300.
What is that?
Sir,
Tell me the words.
the explanation. Sir, any person who does an act with the intention of causing death.
Intention. दूसरा.
So any person who does an act with the intention of causing such bodily injury which he knows that it is likely to cause the death of the
Main thing
person.
is intention.
Yes, sir. So, but the 4th explanation says that any person who does an act which is so eminently dangerous, which is in all probability.
So eminently dangerous.
Yes, sir.
पहला हो गया intention, 4th हो गया so eminently dangerous.
Yes, sir.
और बताइए.
So 304 says that if a person, there are 2 paragraphs. The first paragraph is regarding intention, and the second paragraph is regarding knowledge.
Knowledge.
Yes, sir.
Intention, knowledge,
Knowledge.
so eminently dangerous. 4th one.
So fourth one, sir. Fourth one I told before by mistake that the act was so eminently dangerous that it was in all probability cause. This is the fourth
All
explanation, sir.
probability cause this.
Yes, sir.
So eminently dangerous, or intention and knowledge and so eminently dangerous to cause death.
Yes, sir.
Correct. Now come to your previous question.
Yes,
ठीक
sir.
है? Previous, now come to your previous answer. 300 तो बताया था आपने.
जी सर.
4 लोग मरे थे ट्रक से.
जी सर.
इंटेंशन थी उसमें मारने की.
No, sir. There was no intention.
कैसे 302 हो जाएगा? नॉलेज थी.
Yes, sir. There was knowledge.
नॉलेज. इंटेंशन नहीं था.
No, sir.
तो चारों पैरामीटर तो आए नहीं. तो 302 कैसे हो जाएगा?
Yes, sir. So it will fall under 304 then. So I'm sorry for the mistake.
चलिए सर.
Void agreement and void contract. Do you know
Yes, sir.
what is difference?
So void agreement is one which cannot fulfill the parameters of section 10 of Indian Contract Act, and so it does not become a contract because it becomes it is just an agreement. When the agreement is enforceable by law, it will become a contract, but the contract needs to fulfill certain parameters that has been given in section 10(11). So
Void agreement, void contract.
yes, sir. So void contract is one which cannot be enforced by law because, so like if a minor does a contract, then it cannot be enforced by law.
This is not void contract.
चलिए मैं इसी में ऐड कर दूं थोड़ा सा. सॉरी.
Correct.
माइनर जो है 1 साल बाद मेजर हो गया, तब कॉन्ट्रैक्ट इन्फोर्सेबल होगा कि नहीं होगा?
Ratified कर दिया तो
So if ratified by the minor, it can be enforceable afterwards.
माइनर रेक्टिफाई नहीं करता है और एक साल बाद वो मेजर हो जाता है.
Then the contract becomes void, sir. The contract was void initially because he was a minor.
चलिए
अगर रेटिफाई कर दिया उसके बाद मेजॉरिटी में मेजर होने पर तब
Sir,
वही चीज सेम चीज कर दिया उसने, पूरा कॉन्ट्रैक्ट वही कर दिया.
so if the contract is for the benefit of the minor, and even though he does not rectify, it can be enforced, sir, as per Moheri Bibi, sir.
वो जो हम पूछ रहे हैं वो पूछ रहे हैं कि ये जिसने कॉन्ट्रैक्ट किया था पहले वो माइनर था,
Yes, sir.
बाद में फिर मेजर जब हुआ तो उसी कॉन्ट्रैक्ट को फिर जो है उसने रेटिफाई कर दिया.
Sir, I believe this would not serve to be a contract, sir.
No?
So I believe it would not serve to be a contract because the contract was void from the very beginning, sir.
क्यों? रीजन?
So because the initials of what a contract is was not fulfilled from the very beginning, and then retrospectively it cannot happen.
बाद में रेटिफाई कर दिया उसी कॉन्ट्रैक्ट को फिर से, जैसे 50,000 रुपये उधार दिया था आपसे जब माइनर था, फिर जब मेजर हो गया तो फिर वही 50,000 रुपये वाले नोट पर सिग्नेचर फिर से कर दिया दूसरे ऊपर.
चलिए
So I believe
रेटिफिकेशन जो है तो
Yes.
पीछे से अप्लाई होता है, तो इसलिए एक तो ये रीजन, दूसरा कंसीडरेशन नहीं उसको है.
Okay, sir.
और दूसरे वाले कॉन्ट्रैक्ट में ये फ्रेश कॉन्ट्रैक्ट उसको माने तो कंसीडरेशन का कुछ पार्ट दे दिया जाए उसको,
Okay, sir.
तब तो हो सकता है, वरना अदरवाइज नहीं हो सकता है.
Okay, sir.
चलिए मैं कॉन्ट्रैक्ट से पूछ लेता. मैं एक कंपनी का एमडी हूं, करेक्ट? और रूटीन में एक चेक हमारी कंपनी के मैनेजर ने जारी किया था, वो समहाउ बाउंस हो गया. केस 138 एनआई एक्ट में चला गया कोर्ट में. सेक्शन 141 एनआई एक्ट, न्यू सिविल इंस्ट्रूमेंट एक्ट के अंतर्गत क्या विकेरसली मैं लायबल दूंगा उसके लिए कल जजमेंट आया सुप्रीम कोर्ट का.
So my apologies, sir. I'm not able to recollect the actual law in that thing.
नॉर्मल क्या है? नॉर्मल लॉ इस पे क्या है?
So normal law, if that is not asked, so the master is vicariously liable for the acts of his servant.
नॉर्मल लॉ है।
Yes, sir.
कल सुप्रीम कोर्ट ने इसके अगेंस्ट जजमेंट दिया।
Okay, sir.
कल जजमेंट आया है 2023 का, कल का जजमेंट।
Okay, sir. So I'll read upon it.
नो,
Okay, sir.
सुप्रीम कोर्ट कहता है नहीं, विगरसली ऑटो कोर्स में अगर कोई चेक ऐसे जारी कंपनी के रूटीन बहुत सारे काम होते हैं जिसकी नॉलेज एमडी को हो ही नहीं सकती, पॉसिबल ही नहीं। ऐसे केस में उसके सर्वेंट्स के द्वारा किया गया काम उसके लिए विकेरियसली लायबल नहीं है।
Okay, sir. Thank you, sir.
चलिए सर।
वाइड अवॉइडेबल पे आपसे कॉन्ट्रैक्ट का बहुत सारा सवाल है। अब आप बताइए
जी सर।
कि मैरिज के लिए लड़की का एज क्या होना चाहिए, लड़के का क्या एज होना चाहिए
Sir,
मैरिज
as,
पर्पस के लिए?
sir, as per section 5 clause 3 of the Hindu Marriage Act, the prescribed age for a male is 21 years and female is 18 years.
अगर कोई 20 इयर्स का मेल है
लॉ के अगेंस्ट है।
18 इयर्स से कम ही है
बच्चे क्या करें?
फीमेल, शादी हो गई दोनों की,
अब हमने जिसे अधिकारी ये कहता है भाई हम नहीं देख पाए तो उसको
किसी ने कोई आपत्ति नहीं किया।
अब कह रहा है लाइव नहीं होगा।
वो शादी वाइड होगी, वाइडेबल होगी, क्या बताएगी?
So section 18 of the Hindu Marriage Act provides that if clause 3 of section 5 is taken back, if clause that is infringed or violated, then sir this is a punishable offence. Clause it is a punishable offence, and sir the punishment is 1 lakh rupees is to be paid as penalty, sir. And sir it is not a void contract, because this was done, it was a prospect, it was seeing the prospect of the thing that even today there are child marriages done, and if this particular contract is made void, then sir the societal paradigm is such that that girl will not get married ever after, and that boy will leave her if the contract is void, sir.
समाज में ऐसी बहुत सारी शादियां हो जाती हैं, कहीं कोई आपत्ति नहीं होती है, ना किसी पनिशमेंट होता है, लेकिन दोनों पक्ष अगर 25 इयर्स के हो गए और बाद में किसी ने कहा कि नहीं तो वाइड से शादी इनकी, ये शादी मान्य नहीं होगा, तो क्या स्थिति होगी उस समय? 25 साल हो जाने पर वो शादी वाइड होगा, वाइडेबल होगा या क्या होगा?
Sir, the particular marriage is not void and it is not voidable, sir. Sir, it is just punishable as per law.
वैलिड होगा कि नहीं बाद में?
Sir, I believe it is valid then. So I believe it is valid then.
यस, ठीक।
Thank you, sir.
हाँ, अब आप बताइए कि कोई महिला अपने हस्बैंड को छोड़ के अपने घर रह रही है, उसका हस्बैंड चाहता है कि वो आवे, वो कहती मैं नहीं आऊँगी, क्या कर सकता है?
Sir, he can go to the family court under section 9 of the Hindu Marriage Act for restitution of conjugal rights, and the court will give as per the execution of the particular thing. But sir, there are many views upon the fact that even the court, now that right to privacy has grown to such a limit that a woman cannot, or for that person a male cannot be compelled to go and live with a woman for that purpose. So sir, the law is in abeyance.
कौन से ग्राउंड से जिस पे वो कह सकती कि मैं नहीं जाऊँगी?
Sir, maybe there are grounds that he lives in adultery, or he does not pay maintenance for her, he is not paying her so that she could go out with her household things and all, and sir, he has a second wife, so these can be the grounds for the same, that he does not want to live. So
डिवोर्स के क्या-क्या ग्राउंड है?
So section 13 of the Hindu Marriage Act provides that any of the parties to a valid marriage can go to the court on the grounds of adultery, cruelty, desertion, and that the other person is unsound mind, that the partner cannot be expected to be living with him, and so there is any he has a venereal disease, or he is of such a nature that he has renounced the world.
हो गया।
मैं इतना ज्यादा बीमार पड़ गया, मैं हिल नहीं पा रहा था, मैं बिस्तर पे ही अपने दैनिक कार्य कर रहा था। मीनिंग ये भाई मैं आई एम अनएबल टू गो टू द वॉशरूम, ठीक है, राइट? मेरी पत्नी मुझे रोज उसी हालत में पड़ी रहने देती थी, मेरी पत्नी मेरी कोई सेवा नहीं करती थी, करेक्ट? इसके बाद वो मुझे छोड़ के चली भी गई। क्या ये एक वैलिड ग्राउंड है मेरी पत्नी का मुझसे डिवोर्स लेने के लिए? अभी आपने डिसीज की बात करी थी।
So if it is kind of an incurable disease, and so this is not a ground, it has to be a venereal disease that is done by that is contracted by sexual intercourse, or it is a disease of
नहीं,
unsound mind.
मैं ऐसी बीमारी नहीं है जो वेनरल डिसीज हो, ठीक? तो बहुत सारी बीमारी है, कैंसर से पीड़ित हूँ, आई एम अनएबल टू मूव फ्रॉम माय बेड, तो क्या ये एक वैलिड ग्राउंड मिलेगी पत्नी को मेरे से डिवोर्स लेने की?
So I believe it is not a valid ground for the same, but if the court wants, it can go under Article 142 to give divorce. for that
लॉ
purpose.
क्या है?
So the
What is
law-
the law? Court doesn't want anything. Court has to strictly go with the lines, with the rules, with the law of the land. हम क्या सोचते हैं ये हमारी सोच नहीं है। आप वहाँ क्या सोचोगे ऐसी सिचुएशन में, कल आप जज हो जाओगे, आप वहाँ पर क्या करोगे ऐसी सिचुएशन में? आप डिवोर्स अवॉइड कर दोगे कि नहीं करोगे?
So it is not a valid ground of divorce. So I believe, sir, as per the lines, going through the lines and surpassing the lines would not be a good role as a judicial magistrate, sir.
You will not allow
No, sir.
divorce. क्यों?
So because Section 13 does not provide this as a ground of divorce, sir.
चले सर, गुड।
डिक्री और ऑर्डर में क्या डिफरेंस है?
So decree has been provided in Section 2 Clause A, and so it provides that it is what conclusively determines it is a formal sense of what conclusively determines the rights of the parties with respect to all or any of the matters in issue. It can be preliminary, it can be final, and so
सर ने पूछा व्हाट इज द डिफरेंस बिटवीन डिग्री एंड ऑर्डर, नॉट प्रिलिमिनरी डिग्री, नॉट फाइनल डिग्री,
Okay,
व्हाट इज द डिफरेंस बिटवीन डिग्री एंड ऑर्डर?
And so order has been defined in Section 2 Clause 14. So order, there are many differences. So order is not appealable except in the case of Order 43 and Section 104. And so decree is appealable.
What is the difference between appeal and non-appealable? What you told just.
So appeal is one, like an order has been made by a court to the superior court, the judgment goes so that the court can, it goes to the superior court under Order 41. And so non-appealable means it is a particular decree, it is a particular order against which the judgment cannot go to the higher court. So like Section 95, in that, so compensation is to be given for the purpose of any harm or any inconvenience that has been caused to a person due to supplemental proceedings like getting him arrested, attaching his property. So against that, if a person wants to appeal to the higher court, he cannot.
अभी आपने कहा attaching a property and arresting a person, right? Arrest में अपील कैसे होगी?
So it is so this particular supplemental proceeding that has been given in Section 94 of CPC and Order 38 of CPC provides that an arrest can be made for the execution of a decree. But so an appeal can be made in this case because it is an order.
कब कर सकते हैं arrest?
So arrest can be done for the purpose of execution of a decree.
चल कोई नहीं, don't miss in this time. 151 CPC पढ़ा है? क्या है?
So inherent powers of the court.
Inherent power क्या है? Inherent power क्या है?
So nothing in the code shall restrict.
हाँ.
Nothing in this CPC shall restrict the court from passing any order that is for the purpose of ends of justice and to prevent the abuse of process of court.
End of justice and to prevent the abuse of the process of the court.
Yes.
We have only 2 points, right? Correct? मैंने जज साहब की जमीन पे कब्जा कर लिया। कब्जा कर लिया, जज साहब की जमीन थी, मैंने लाके कब्जा कर लिया, ट्रैक्टर लगाया, उसको फेंसिंग लगा दी मैंने उसको। केस आपके पास आया, तो 151 में आप क्या करोगे उसमें?
So I would grant an injunction for the same, that from deterring.
Under section CPC 151.
Sir, yes, sir, I cannot grant injunction under 151 because a particular provision is already present, so I cannot grant injunction under 151. I have to do something which is not given in CPC. So, sir, I believe I will deter you from not doing the same.
151 का यूज वहाँ होगा जहाँ कोई चीज बचा नहीं हो सीपीसी।
Yes, sir. Yes, sir.
Order 39 already available.
Good. Very good.
Thank you, sir.
39 है ना?
Yes, sir. Yes, sir. So
51 में जाने की जरूरत नहीं।
yes, sir. I just got it after 2 seconds.
Sir,
Please. So you are from Dr. Raman Lohia.
Yes, sir.
Okay. Dr. Lohia got a PhD in what subject? He's a doctor, Dr. Raman Lohia.
Yes, sir. So my apologies, sir. I don't remember it, sir.
Okay,
Right now.
sorry.
Yes, sir.
There have been a number of leading cases associated with Dr. Lohia.
Yes, sir.
Can you name a few cases? They all went up to Supreme Court and they did the law.
Yes, sir. So
Justice Hidayatullah made a very important judgment in one of the cases. The state of Bihar versus Dr. Lohia.
So I cannot reflect
It
it.
concerns which part of Constitution? The state of Bihar, then Superintendent Central Jail versus Dr. Lohia. It concerns which part of Constitution?
So unlawful assembly?
Hmm?
Unlawful assembly? So not the constitution.
no.
Check.
So,
Another case?
yes, sir.
He was arrested under Defense of India rules.
Okay.
Details rather.
So sedition?
I am talking about the Constitution.
Okay, straight with
sedition
the
goes to
constitution.
IPC.
Yes, sir. Yes, sir. Sorry, sir.
Okay. And I have given you the clue also. Defense of India rules.
Yes, sir.
Okay, now let's move to the. I will answer that later on. Because you are from
Sorry,
Dr.
sir.
Lohia.
Yes,
and
yes, sir. I
so-
should know that, sir. I'm very sorry.
Sorry.
इस तरह के होते हैं।
Yes, sir. Yes, sir. I'm sorry.
Procedure established by law. That's what Article 21 says. But in Rayappa and Maneka Gandhi, there was some deviation from that. What was the deviation? What was the finding in Maneka Gandhi and in Rayappa?
Okay. So, in Menka Gandhi, the Honorable Supreme Court had very appropriately decided that there should be a golden triangle of Article 14, 19 and 21. That should be first considered before considering a law.
Okay.
That is
That's the one part.
Yes, sir.
Second thing,
So, in
Rayappa.
So in E.P. Royappa, there was a dynamic concept that was invented. That if we are bringing it to the fact that there is Article 14, 19, 21, the concept should not be very constricted. That there is Article 14 and it is about right to equality. The concept should go to beyond this particular fact, and it should become to a dynamic concept rather than constricting it to 14, 19 and 21, sir.
There are some very specific words quoted by Justice Bhagwati.
Sir, Justice Bhagwati.
Rayappa has been followed later on also, or there have been
Yes, sir.
exceptions to
Sir,
Rayappa?
it is a landmark case, sir.
There have been exceptions to Rayappa also later on? Some deviations from there?
So I believe no. After A.P. Royappa, there was no
Keshavan
deviation.
Bharti case you are aware?
Yes, sir.
What were the constitutional amendments involved in Keshavan Bharti?
So, 24th Constitutional Amendment and 25th Constitutional Amendment.
Okay.
So, 24th Constitutional Amendment had added Article 14 Clause 4 and Article 368 Clause 3,
Okay.
which provided that
So
nothing
what
in
was
this.
the judgment? Which amendment they upheld and what part of amendment they rejected?
So, in Keshavananda Bharti case, it was upheld that the Parliament shall have the power to
Under
amend.
no amendment. Which part
हाँ,
of
the
it?
Parliament shall have the power to amend the Constitution, but subject to the basic structure of the Constitution. And so the part of amendment that was. So can you please repeat the last
Sure,
part,
sure.
sir? So
24th, 25th Amendment, which part were accepted by the Keshav Bharati and what was held ultra vires?
So the part that was accepted was that the Parliament shall have the power to amend any part of the Constitution. And so what was ultra wise was that the judicial review should not be taken away from the court, because that is the basic structure of the Constitution.
And how it was elaborated in Minerva Mill?
So Minerva Mills basically had it was about 42nd Amendment of the Constitution passed in 1976, which had added clause 4 and 5 to Article 368, which say that nothing, no
42nd
amendment.
Amendment added the word secular.
Okay, sir.
But even before that, it was held that secular is a part of our constitution. Which case said that secular is a part of basic?
Sir, S.R. Bomai versus Union of India.
Before that also? When was the Mumbai case decision came?
So the year? Sir, I am not able to
After
recollect.
42nd Amendment or before 42nd Amendment?
Sir,
We are looking
Sir.
for something before 42nd Amendment.
yes, sir, it was after 42nd Amendment. So, just a moment.
Sure.
So even in Keshavananda Bharati, it was held that
Correct.
secularism is the
The
basic
Chief
structure of the
Justice
Constitution.
himself noted secularism is a part of
Yeah, basic structure, yes, sir.
Essential practices of religion. Can you name the case law? PVR?
So, Shaira Banu versus Union of India, Shah Banu Begum versus Union of India, Muhammad Ahmed versus Union of India.
The first case dealing with EPR,
Essential practice.
where the principle of EPR was held. What is EPR?
So, essential practices of religion are those that have been enumerated in Article 25 of the Constitution.
Okay.
And so subject to public health, morality and part 3 of the Constitution, public order. Every citizen of India shall have the right to practice, propagate, profess any religion. And so if anything falls within this paradigm, then a person shall have the right to practice that particular essential tenet that he wants to practice.
IPC, lot of amendments are going to take place. How many sections are going to be repealed and how many sections are going to be amended?
So I did not go through that, sorry sir.
Sorry.
So I'll read upon it.
Now we will do the
Can I ask one more question?
Sure.
Any other question?
Ji.
Secular word is added
Very
recently, very recently. Amendment. जब हम किसी चीज को ऐड किया है हमने, डॉक्टर साहब, जब हमने सेकुलर वर्ड को ऐड किया, ठीक, कॉन्स्टिट्यूशन तो हमारा बहुत पहले बना था, उसके कई दशक बाद हमने सेकुलर शब्द को ऐड किया। तो ये बेसिक स्ट्रक्चर कैसे हो सकता है? जब ऐड हो सकता है तो क्या डिलीट नहीं हो सकता?
Sure, sir. So if it can be added, it can be deleted. But sir, because of the sir.
सुप्रीम कोर्ट ने इसको बेसिक स्ट्रक्चर बताया है,
Yes.
सेकुलर वर्ड।
So because of the fact that the Honorable Supreme Court has pronounced that it is the basic structure, so now it cannot be amended. But it could have been amended before the 1973 judgment of Keshavananda Bharati, sir.
सर,
You can now just give the
Yes.
feedback.
चलो।
Thank you.
Your knowledge is very good.